We handle all types of adoptions, and so when you come and meet with us, we'll walk through all the different types of adoptions with you to see what works best for you and your family.
So there are independent adoptions, agency adoptions, foreign adoptions, and also adoptions from the state, which are also called DFACS or DSS adoptions. ICPC is the Interstate Compact on the Placement of Children, and it is a compact between all 50 states that regulates the flow of children between states. So if you're adopting from a state different from where you reside, you will have to go through the ICPC process. And we are quite experienced at assisting you with that ICPC process. It involves sending in a thick packet with documents signed by the mother who's placing the child for adoption, as well as the adoptive parents. You have to include their home study and other documentation, and that packet has to be approved by both the sending state, that is the state where the child is born, as well as the receiving state, which is where the adopting parents reside.
So because you have to have the approval from both states, it's very helpful to have an attorney that's worked with ICPC in different states and knows how to get your case through the process, because you'll need to get through both the process in the home state as well as the state that you're traveling to. Sometimes we have adoptive parents that want to know, can they help pay reasonable living expenses for the expectant parent? And the answer is yes, but it has to go through either an attorney or an agency in Georgia.
In North Carolina, it's actually a little bit more liberal. Adopting parents can pay reasonable living expenses during the pregnancy and for up to 6 weeks after the birth of the child. And that is really the only direction that we have. So in both states, North Carolina and Georgia, it is permissible to pay living expenses, but we do recommend consulting an experienced adoption attorney before actually providing any expenses to an expectant mom that you may be matched with.
And so it's important to know what the laws are in the particular state that you're working with.
In North Carolina, a birth father who doesn't consent to the adoption, they have to be notified after the petition for adoption is filed. And at that point, the alleged biological father has 30 days to respond. In certain circumstances, that notification can be by publication. That would be if he is unknown or unfindable. And from there, if he does object, there's a court process that we would go through to determine whether his consent is required. In many cases, the biological father doesn't respond, and in that case, we are able to move the adoption forward without his participation or consent.
We've been building and securing families
for over 30 years.